Hello everyone. Today we will be discussing some multiple choice questions on intellectual property rights, that is IPR. In this video, we will be taking up some questions on patent rights. So, without wasting much time, let's start our video. Question 1. Which section of the Act provides the publication of a patent application by the controller? Option A, Section 10. Option B, Section 11A. Option C, Section 11B. Or Option D, Section 12. The correct answer for this question is Option B, Section 11A. Question number 2. Application for patent shall ordinarily be open to public after a period of Option A, 10 months. Option B, 12 months. Option C, 15 months. Or Option D, 18 months. The correct answer for this question is Option D, 18 months. Question number 3. Which form is to be filled for seeking early publication for the patent application? Option A, Form 1. Option B, Form 9. Option C, Form 10. Or Option D, Form 12. The correct answer for this question is Option B, Form 9. Question number 4. The applicant has to make a request for examination of the application for a patent within Option A, 20 months from the date of filing of the application. Option B, 24 months from the date of filing of the application. Option C, 36 months from the date of filing of the application. Or Option D, 48 months from the date of filing of the application. So, the correct answer for this question is Option D, 48 months from the date of filing of the application. Question 5. Patent application in India can be opposed during Option A, pre-grant of the patent. Option B, post-grant of the patent. Option C, both Option A and Option B. Or Option D, after registration. The correct answer for this question is Option C, both Option A, pre-grant of the patent, and Option B, post-grant of the patent. Question number 6. A post-grant opposition under the Patents Act 1970 can be filed within Option A, 1 year from the date of publication of grant of patent. Option B, 6 months from the date of publication of grant of patent. Option C, 2 years from the date of publication of grant of patent. Or Option D, 1 month from the date of publication of grant of patent. The correct answer for this question is Option A, 1 year from the date of publication of grant of patent. Question number 7. A post-grant opposition under the Patents Act 1970 can be filed by Option A, any person. Option B, applicant of patent. Option C, person interested. Or Option D, design engineer. The correct answer for this question is Option C, person interested. Question number 8. Grounds of pre-grant opposition are given under which section? Option A, Section 24. Option B, Section 25, Clause 1. Option C, Section 25, Clause 2. Or Option D, Section 25, Clause 3. The correct answer for this question is Option B, Section 25, Clause 1. Question 9. Section 25, Clause 2 of the Patents Act 1970 deals with Option A, inventions not patentable. Option B, grounds for pre-grant opposition. Option C, grounds for post-grant opposition. Or Option D, grounds for revocation of patent. The correct answer for this question is Option C, grounds for post-grant opposition. Question number 10. Which form is filled for the opposition for the grant of a patent? Option A, Form 2. Option B, Form 3. Option C, Form 6. Or Option D, Form 7. The correct answer for this question is Option D, Form 7. Pre-grant opposition. Section 25 Clause 1 of the Act provides provisions for pre-grant opposition of patent. Under this provision, any person or any third party or government may challenge the application of grant of patent and inform to the controller of patents for opposition in writing against the grant of a patent after the application for a patent has been published but before the grant of a patent. Pre-grant opposition can be made on the grounds listed under Section 25 Clause 1 of the Act. Some of these grounds are: Number 1. Wrongfully obtaining the invention. Number 2. Anticipation by prior publication. Number 3. Non-patentable subject matter. Number 4. Insufficiency of description of the invention. Number 5. Prior public knowledge or public use in India. Number 7. Obviousness and lack of inventive step. Post-grant opposition. Post-grant opposition may be filed at any time after the grant of patent but before the expiry of a period of 1 year from the date of publication of grant of the patent. Under this provision, any person interested may give notice of opposition to the controller in the prescribed manner. Similar to the pre-grant opposition, a post-grant opposition may be filed on a number of grounds as specified under Section 25 Clause 2 of the Act. Question number 11. If any improvement or modification is made to the main invention, then the patentee will have the right to get Option A, extra patent, Option B, process patent, Option C, product patent, or Option D, patent of addition. The correct answer for this question is Option D, patent of addition. Question number 12. A patent of addition is granted for a term of Option A, equal to the term of that of a main invention. Option B, 20 years from the date of grant of the patent. Option C, 20 years from the date of filing of patent. Or Option D, equal to the term of that of main invention, or so much so thereof which has not expired. The correct answer for this question is Option D, equal to the term of that of main invention, or so much so thereof which has not expired. Question number 13. Patent right can be licensed by Option A, exclusive license agreement. Option B, non-exclusive license agreement. Option C, sole license agreement. Or Option D, all of the above. The correct answer for this question is Option D, all of the above. Question number 14. Who can file a petition for revocation of a patent? Option A, any person interested. Option B, the central government. Option C, person making a counterclaim in a suit for the infringement of a patent. Or Option D, all of the above. The correct answer for this question is Option D, all of the above. Question number 15. Grounds of revocation of patent is given under which section? Option A, Section 60. Option B, Section 63. Option C, Section 64. Or Option D, Section 84. The correct answer for this question is Option C, Section 64. Question number 16. Patent can be revoked due to Option A, non-working of patent. Option B, working of patent. Option C, both Option A and Option B. Or Option D, none of the above. So the correct answer for this question is Option A, non-working of patent. Question number 17. Compulsory licensing denotes Option A, statutory licensing. Option B, voluntary licensing. Option C, non-voluntary licensing. Or Option D, both Option A and Option C. The correct answer for this question is Option D, both Option A, statutory licensing, and Option C, non-voluntary licensing. Question number 18. compulsory licensing can be granted due to option A, denial of license by patentee, option B, increase of price of patented drug, option C, both option A and option B, or option D, none of the above. The correct answer for this question is option C, both option A, denial of license by patentee, and option B, increase of price of patented drug. Question number 19. The first case on compulsory licensing in India is option A, Hoffman La Roche Limited versus Cipla Limited, option B, Bayer Corporation versus Union of India, option C, Bishwanath Prasad Radheshyam versus Hindustan Metal Industries, or option D, Novartis AG versus Cipla Limited. The correct answer for this question is option B, Bayer Corporation versus Union of India. Question number 20. Patent can be revoked by the controller for the non-working after the expiry of option A, 14 years from the date of granting compulsory license, option B, 2 years from the date of granting compulsory license, option C, 5 years from the date of granting compulsory license, or option D, 1 year from the date of granting compulsory license. The correct answer for this question is option B, 2 years from the date of granting compulsory license. Compulsory licensing. In Novartis AG versus Cipla Limited, the court stated that an obligation is imposed on the patentee to work the patent in India on a commercial scale and to the fullest extent. The patent may be worked by the patentee himself or through licensees. Failure to fulfill this obligation will entail in the granting of compulsory licenses or revocation of the patent itself. Section 92A of the Act provides that compulsory license shall be available for manufacture and export of patented pharmaceutical products to any country having insufficient or no manufacturing capacity in the pharmaceutical sector for the concerned product to address public health problems, provided compulsory license has been granted by such country or such country has, by notification or otherwise, allowed importation of the patented pharmaceutical products from India. Question number 21. Right to sue in a patent infringement suit vests with option A, patentee, option B, exclusive licensee, option C, compulsory licensee, or option D, all of the above. The correct answer for this question is option D, all of the above. Question number 22. Suit for patent infringement is to be filed in option A, High Court, option B, District Court, option C, Supreme Court, or option D, Intellectual Property Appellate Board. The correct answer for this question is option B, District Court. Question number 23. The central government can acquire inventions and patents. Option A, free of cost. Option B, by paying compensation. Option C, both option A and B, or option D, they cannot acquire them. The correct answer for this question is option B, by paying compensation. Question number 24. A brand new way to process edible oil to make it healthier is covered under option A, copyright, option B, trademark, option C, patent, or option D, industrial design. The correct answer for this question is option C, patents. Question number 25. SEP is an acronym for option A, Software Essential Patent, option B, Software End Protocol, option C, Standard Essential Patent, or option D, Standard Essential Protocol. The correct answer for this question is option C, Standard Essential Patent. That's all for today. I hope you all learned something new. In our next video, we will discuss some questions on industrial designs and traditional knowledge. Keep learning. All the best.